230 matters, petition 2347 of 2022 on Kannada matters.
May it please, my lord.
Just before my learned friend Mr. Kamath begins, yesterday your lordships were taking a list of the matters, IAs in support of the petitioner. I'm sorry I missed it out. I also have an IA number 13, and it's by a women's rights organization. Your lordships will make a note of it. Whenever your lordships permit, I'll argue in my turn.
You moved an application for intervener.
That's right, I'm an intervener supporting the petitioners, on multiple grounds.
Which writ petition you have moved?
Item number 1, in WP 2347.
All right.
Yes, grateful.
May it please, my lord.
Lordship.
Yes.
I filed an affidavit before in the morning, Lordship. It also is the record, Lordship. I just wanted to point out, bring the fact before this honorable court. The order which is passed by this honorable court, it is grossly misused by the state lordship. But to kindly take the para number 11, the order, it clearly says that it is only respect of those colleges where college development committee has prescribed the inform. In spite of that, they are imposing it to every institution's lordship. Muslim girls are forced to remove their hijabs. Even yesterday in Gulbarga, government officials went to Urdu schools. They forced students as well as the teachers.
Have you moved any application?
I have given an affidavit, Lordship, in that aspect.
Affidavit will not serve the purpose. You move an application for clarification.
Lordship,
if you move an application for clarification, seeking some clarification of some order, then we can clarify that. In what context the order has been passed in.
Lordship, but the fact is that apart from misuse, the clarification, Lordship, it's getting misused by the authorities, Lordship. That facts I want to bring before this honorable court.
All right, you will direct the respondents.
And I have presented all the media reports, which has been today's media reports, and how it has been.
Direct the respondent to seek instructions on this.
I may only point out that there is no application. There is some memo. No, allow me to complete, sir. There is a memo, and it is a memorandum of facts is been sworn to by the council appearing in the matter, and there is no statements. Kindly peruse, it is as vague as it is permissible. Let them come up with a proper application and a proper prayer. We'll respond to that. We can't respond to such kind of vague allegations. And there is absolutely no affidavit by the party lords who has filed the petition.
I myself have not filed application. I filed affidavit to state some facts of the matter.
Who has filed the affidavit?
I only have filed the affidavit, Lordship. These are the facts.
That you cannot file an affidavit.
No, Lordship, I am not moving any application. For that reason, I am not.
We don't think that a lawyer can file an affidavit.
These are
in a case that would amount to misconduct.
My humble submission, Lordship. These kind of incidents are happening in society, which is affecting the.
Whatever, don't become a party to the litigation.
Court will look into it. Let's start. The court is in season of the matter. Court is aware of all these things. So let me proceed. Lord, sir, I was yesterday, my lord. Lord, if I can request the court master, I can't see the honorable court, my lord. The focus is on the my lord, the audience, the lawyers, my lord. I can't see. I'm grateful, my lord. My lords, first of all, my lord, your lordships have lord had the pain, my lords, of hearing me for over, my lords, 4-5 hours, and I'll be very brief, my lord. I will try to sum up, my lord, my balance arguments. But a couple of queries.
Our request is that one lawyer in one case.
Yes, my lord. Yes. My lords,
we will
a couple of queries.
One lawyer one to argue the matter.
Yes, my lord. My lord, yesterday a couple of important questions had fallen from the honorable court, and my lord, I was on the question of public order, and my lord, an important observation which was made by this honorable court is, why are you emphasizing on public order? The state has not said so, and in that connection, my lord, I had brought the attention of this honorable court to the last portion of the GO, which talks about, my lord, Sarvajanika Suvyavasthe. And according to us, my lord, this is public order. Now, there is some disturbance. If others can mute their mics, please. The court may get disturbed. So, my lord, the state objected.
Give the government order. Copy of government order.
The Kannada word which is used, my lord, is Sarvajanika Suvyavasthe. and the state says, my lord, that this is capable of more than one meaning, if I have understood the learned AG right, and it does not mean,
Yes.
and it does not mean public order. That was the argument which was made, and the learned AG said, my lord, that the interpretation, the translation was not correct, etc. So, my lord, I had to go to the official translation of the Constitution of India in Kannada, which is released by the Government of India. And if I can just place that for the benefit of this honorable court, Shahul, can you just hand it over to the court master, please? And my lord, lordships will see that all the articles in the Constitution which use the word public order, the Kannada translation is Sarvajanika Suvyavasthe. It is as clear as day, my lord. I'm really surprised that the state even, my lord, took up this argument that this is capable of more than one meaning. But I'm really surprised. Either they have not opened the Constitution or they have not bothered to see the translation. Either of these two, my lord. Just have a look at, my lord. Yes, my lord.
Mr. Kamath,
Yes, my lord.
we are interpreting an order made by the government.
Yes, my lord.
We are not interpreting the terms employed in a legislation, much
Agreed,
less
my
a
lord.
constitutional document. The
Agreed, my
settled
lord.
legal position is where certain terms are employed in the government orders. We cannot interpret them on par with the terms employed in statutory instruments, legislations. This is how law is structured.
Agreed, my lord.
Therefore, we cannot just because these two words are used, we cannot equate them with NT1 list 2 of 7th schedule was my answer to you. We
Yes,
are
lord. May I answer? May I respond to that, my lord? Lords, I respectfully submit that the word Sarvajanika Suvyavasthe, which has been used in the order GO, my lord, is not capable of two meanings. That's my first submission. It's up to your lordships, my lord, to accept it or not.
That's right.
It is as clear as day, my lord. It is not a Narova Kunjarova, my lord's doctrine. ये भी हो सकता है, वो भी हो सकता है. It's not that case, my lord. Because public order, as per the Constitution, in Kannada is Sarvajanika Suvyavasthe. And, my lords, if the government thinks that the words which it employs can have a different connotation, can have a different meaning than what is assigned in the Constitution, I am sorry, my lords, that is an interpretation which, my lord, which does not flow from any, my lord's constitutional doctrine. What is there in the Constitution is public order, Sarvajanika Suvyavasthe. And, my lord, if the state has used that term in the GO, that has to be given the same meaning. So just, my lord, just to end this point, if your lordships have this Kannada Constitution, lords, interestingly, I was just going through the word public order, my lord, in the Constitution is used 9 times. And just for the lordship reference, lordships may not make a note of it. 19.2, 19.3, 19.4, 25.1, 26, 88B, 6th schedule item 15, 7th schedule list 2 item 1, and list 3 item 3. All places, my lord, uniform Kannada word which is used is Sarvajanika Suvyavasthe. Just one page, if your lordship see Article 25, how it is interpreted, my lord. And just before that, my lord, it's very interesting why this document was made available in Kannada by the Government of India. And it says, my lord, as a part of the, just have a look at the preface, my lord. You know, since we are students of constitutional law, lordships, yesterday, my lord, told me to get an authoritative translation, my lord. And, my lord, I had an occasion to learn because of that. But for that question, my lord, I would not have had the benefit of actually, my lord, going through this. Just have a look at the preface, my lord. the present digital.
You have seen the judgment of Apex Court.
Yes, ma'am.
Justice Hikayatullah, Honorable Justice Hikayatullah's comment
Yes,
in
ma'am.
Sajjan Singh's case.
Yes, Milord.
I don't want to play the role of a grammarian.
Yes, Milord. I vote on Milord.
Such question arose.
Yes.
When such question arose, this was
Yes.
the comment of the Apex Court, the great
Correct.
judge of the Apex Court.
Correct, Milord. Absolutely. Milord, just kindly have a look at paragraph 2. The present DigiLoad edition of the Constitution has been prepared by the Parliamentary Affairs Department, so and so, as a part of the implementation of the decision of the central government to make available the Constitution of India and central laws to the general public in their own regional official language to enable them to know the law of the land. And this is a guidance to the state as well, my lord. In its true spirit, to fulfill the constitutional mandate. Now, my lords, may kindly turn to page Article 25, which your lordships will find. The English version is at page 13. Subject to public order. And the Kannada version is the next page, my lord. Sarvajanika Suvyavasthege. ನೈತಿಕತೆಗೆ ಮತ್ತು ಆರೋಗ್ಯಕ್ಕೆ ಹಾಗೂ ಈ ಭಾಗದ ಇತರ ಉಪಬಂಧಗಳಿಗೆ ಒಳಪಟ್ಟು ಎಲ್ಲಾ ವ್ಯಕ್ತಿಗಳು ಅಂತಃಸಾಕ್ಷಿ ಸ್ವಾತಂತ್ರ್ಯಕ್ಕೆ ಸಮಾನ ರೀತಿಯಲ್ಲಿ ಹಕ್ಕು ಉಳ್ಳವರಾಗಿರುತ್ತಾರೆ ಹಾಗೂ ಅಬಾಧಿತವಾಗಿ ಧರ್ಮವನ್ನು ಅವಲಂಬಿಸುವುದಕ್ಕೆ ಆಚರಿಸುವುದಕ್ಕೆ ಮತ್ತು ಪ್ರಚಾರ ಮಾಡುವುದಕ್ಕೆ ಹಕ್ಕು ಉಳ್ಳವರಾಗಿರ್ತಾರೆ. So my lord, very categorically that Sarvajanika Suvyavastha is public order, and I rest my case with this, that the government order uses the term Sarvajanik Suvyavastha. It cannot have an interpretation other than what is there in the Constitution. That's my first point. The second point, my lord, an important question which fell from the bench yesterday, and a very pertinent question, that why are you only going on Article 25(1)? And that question, my lord, fell from the Honorable the Chief Justice. There is also 25(2), and 25(2) talks about reform, and whether that reform can apply even to essential religious practice. My lord, that is answered by the Supreme Court in a Constitution bench decision in 1962 supplementary SCR, page 496. Lords, I'll just place, I'm not going to place the facts, but very interesting facts, my lord.
Name of the case.
Yes,
1962.
it is 1962, 2 SCR 496, Sardar Sayedna Tahir Saifuddin versus state. But I'll just place the facts. Lord, this pertains to the Bohra community. And my lord, what had happened was that the Bombay legislature passed a law saying that the head of the community cannot excommunicate a member of that community on the ground that he had violated religious norms. So, my lord, a penal consequence was provided which in the community law, which said that, look here, if you violate religious injunctions, you will be excommunicated from the community. So a law was brought in to prohibit that, to abolish that. And 32 petitions were filed, my lord. And the Supreme Court, my lord, said that if it is a part of essential practice, even this, my lord, was upheld. So kindly see, my lord, in that context, just a few pages, the opinion of the majority is, my lord, of Justice Das. And if I can just place para, my lords, page 553 of the report. Das and Iyengar, my lord, entering, and Justice Sinha is dissenting, and dissent is even more interesting. I'll just place that. I'll place the majority first. Para page 553 of the report.
553. Last but one page.
Yes, my lord.
Last but one page.
Yes, my lord. I'm grateful. I'm grateful. My lord, the second paragraph, in my view, the phrase laws providing for social welfare and reform, it was not intended to enable the legislature to reform a religion out of existence or identity. Article 25(2)(a), having provided for legislation dealing with economic, financial, political, or secular activity which may be associated with religious practices, the succeeding clause proceeds to deal with other activities of religious groups, and also these must also be those which are associated with religion. Just as the activities referred to in 25(2)(a) are obviously not of the essence of religion, similarly, the saving in Article 25(2)(b) is not intended to cover the basic essentials of the creed of a religion which is protected by 25(1). So, my lord, if it is an essence of the religion, neither under my lord's 25(2)(a) or B, my lord, that can be, my lord's, curtailed. Subject to, my lord, of course, public order, morality, and health. These are overriding considerations. And, my lords, what is public order? There is, my lord, the majority was struck down the law on the ground that it violates 25. The minority, my lord, Justice Sinha, upheld the law. But, my lord, what he says at page 519 is interesting, and that is probably the law, my lord. Even the minority says that what is the extent to which the state can interfere a religious practice on the ground of public order should be something, my lord, which is abhorrent, which by itself, my lord, would create a certain degree of disturbance in society. And that, my lord, lordships will find at page 519. Page 519, somewhere in the middle of the page.
Yes, SCRs are like that.
I'm sorry, my lord, the SCR, the problem is, my lord, there are no paragraphs and there are no placitums also, my lord. So it's a little difficult for us to assist your lordship, but somewhere in the middle of the page, I requested my friends not to take printouts because long judgment I had marked from the SCR, my lord. So I requested them to give a printout of this, copy of this.
Yes, SCR is the only authoritative.
Yes,
This is the only authoritative publication.
Yes, my lord, that's right, my lord. We refer to SCC, my lord, as a matter of practice, but your lordships are right, my lord. SCR is the only authoritative publication. A person is not liable to answer the verity of his religious views, and he cannot be questioned as to his religious beliefs by the state or by any other person. Thus, though his religious beliefs are entirely his own and his freedom to hold those beliefs is absolute, he has not the absolute right to act in any way he pleased in exercise of his religious beliefs. He guaranteed the right to practice and propagate his religion subject to limitations aforesaid. His right to practice his religion must also be subject to criminal laws of the country, validly passed with reference to actions which the legislature has declared to be of penal character. Laws made by a competent legislature in the interest of public order and like restricting religious practices would come within the regulating power of the state. For example, now kindly see, my lord, this is the guidance which the Honorable Supreme Court gives. For example, just see this, my lord, religious practices of sacrifice of human beings. Just see this, my lord, abhorrent. Or sacrifice of animals in a way deleterious to the well-being of the community at large. It is open to the state to intervene by legislation, to restrict or to regulate to the extent of completely stopping such deleterious practices. It must therefore be thought that the freedom of conscience is guaranteed to every individual so that he may hold any beliefs he likes. His actions in pursuance to those beliefs may be liable to restriction in the interest of the community at large, as may be determined by common consent, that is to say, by a competent legislature. It was on humanitarian grounds and for the purpose of social reforms that so-called religious practices like immolating a widow at the fire of her deceased husband or of dedicating a virgin girl of tender years to a god to function as a devadasi or of ostracizing a person from all social contact and religious communion on account of having eaten forbidden food or taboo were stopped by legislation. So, my lord, there is some amount of guidance as to how, my lord, this power, my lord, of the state has to be exercised. Now, my lord, in this particular case, lordships will see what is in question is an innocuous practice. Lordships have seen, my lord, Article 25. And, my lord, words used here are freedom of conscience and the right freely to practice and propagate religion.
Raju, interested to Yes.
Yes, ma'am. Lord, the two, what I was submitting is, Lord, what flows from this judgment, especially Justice Sinha's judgment, is this: that, my lord, the guidance to the state in stopping a religious practice is that it should be something which is abhorrent, which has a deleterious effect on society. Then the state, on the ground of public order, morality, or health, can stop it. Now, in this case, my lord, this is an innocuous practice of wearing a headscarf. And, my lord, the constitution consciously, our framers, my lord, had great foresight. Ambedkar, my lord, and all the others, luminaries, my lord, had great foresight. They used the term freedom of conscience, my lord. And this has a lot of depth, my lord. My lord, what it protects is an innocent practice of faith. It protects an innocent practice of faith, but not, my lord, a display of religious jingoism. Kindly see this, my lord. And I make these submissions with the utmost of respect and humility at my command. The essence of Article 25 is it protects the practice of faith, but not a mere display of religious identity or jingoism. My lords, kindly see. My lords, when I was in school, my lord, and college, I used to wear, my lord, a rudraksha on my neck. My lords, it was not a case of displaying my religious identity. My lords, I wore it because I felt a certain degree of protection, a certain link, my lord, with my creator. Lordships have seen, my lord, so many lawyers, senior lawyers, judges, my lord, where, my lord, certain customary, my lord, religious namams or whatever, my lord. This is not, my lord, a display of religious identity. It is, my lord, a practice of faith. That is what is protected by Article 25. To counter that, my lord, somebody wears a shawl, he will have to show, my lord, that is it a display of religious identity alone, or is it something more? If it is sanctioned by Hinduism, my lord, by our Vedas, Upanishads, or our scriptures, your lordships are duty bound to protect it. If not, my lord, then Article 25 doesn't protect it. That's the submission, my lord, which I wanted to make. The last, my lord, submission on this point, which the query which fell from your lordships yesterday, is that there is a law. State argues there is a law. There is an Education Act. Education Act is there. And under the Education Act, there is a 133 power. 133 power, they have made an order, and there is one earlier circular. And therefore, we have a law. And that law can curb the religious freedom. Not is it the way we are going to interpret Article 25? When the Article 25 says, my lord, that a law can be enacted to curb a religious practice on the ground of social reform, the law must explicitly, my lord, show that intent. Does the Education Act show that intent? It cannot be my understanding, my lord, or the state's understanding by way of an affidavit that by way of the Education Act, we can curb anybody's religious freedom. The legislature ought to have applied its mind, and that application of mind should be demonstrated by a provision of the act itself or a statement of object and reasons. Otherwise, my lord, it's a very dangerous proposition, which the state is saying there is some act, Education Act, and we will rely upon it to curb somebody's freedom, relying upon the Article 25(2)(b), which says that we will make provision for social reform. The legislation itself, my lord, has to demonstrate ex facie that the legislation has an intent to reform, which is not the case, which can't be the case. And they can't explain it in an affidavit.
Education Act is not under challenge before us.
No, my lords, it is not. That's what I'm saying. And the submission is this, that the Education Act, by any stretch of imagination, my lord, there is not even one iota of contemporaneous evidence to show either from the assembly debates or from the statement of object and reasons that this is a law which has been enacted for the purposes of curbing, my lord, hijab, or for that matter, my lord, stopping a religious practice. There has to be a specific intent. That is not there, my lord. So that's, my lord, the 3 points, my lord, 2 points which fell from the court, which I thought I had a duty to answer. My lord, the other, my lord's point which the Honorable Court asked me yesterday, that are there any other jurisdictions apart from, my lords, Muslim countries, my lords, which have gone into this aspect of hijab and how they have treated it with, my lord, constitutional rights? And that I thought, my lord, was a very, very pertinent question, and we did some homework, my lord. And I will cite one or two cases, and it is actually fascinating, my lord, because lordships, when I was arguing before the learned single judge, my lord, Justice Dikshit, he cited a very, my lord, interesting shloka of the Rigveda. He says, "Ano bhadra krutvo yantu vishwataha," that let noble thoughts come from all directions. So, my lord, I will just take your lordships to a few of these countries which have similar, my lord, constitutional paradigm, and I will show, my lord, how religious rights, when compared with, my lord, competing rights, like rights of the school to maintain discipline, uniform, how, my lord, courts have responded to that. My lords, the first judgment I want to cite is a judgment from the South African High Court. That is, my lord, Anthony versus governing body. It's a matter of headscarf, my lord. If I can just ask my instructing counsel to just hand over. Anthony versus governing body. That is, my lord, 2004 essay 738. Anthony versus governing body. But principles are quite, the facts are quite similar. Lords, here the applicant.
Two things you have to say.
Yes,
Is it a theocratic state?
No,
Does
Lord,
it
it's
have a written constitution?
Yes, written
In light
constitution.
of that, you have to analyze that.
Yes, my lord. I will just, I'll place that also. That's a very important question, my lord. The jurisdictions which I'm going to cite, my lord, are not theocratic states. These are states, my lord, which are bound by a written constitution, except for England. But South Africa, my lord, I will show how their rights regime is similar to ours. But in the next judgment, this is the High Court, and I'll cite the Supreme Court. My lord, this is the case, paragraph 3. Paragraph 3 of the judgment, my lord. What is the issue?
Name of the case. Mr. Kamath, please read name of the case, because so many friends are here. They should hear what you say, apart from us.
I'm sorry, my lord. I'm sorry. I'm so sorry, my lord. I beg your lordship's apology. Anthony versus governing body, Settlers High School and others, 2002, 4 essay 738. And it is a judgment by Justice Van Zyl. And the facts are not noted in paragraph 3. The salient facts and circumstances may be dealt with briefly. The applicant became interested in various religions at an early age. During December 99, she decided to embrace the principles of Rastafarian religion, some African faith. One of these principles is that Rastafarians are required to grow their hair into so-called dreadlocks. But I was not aware of what is a dreadlock. I asked my friends. It's not probably the hair grows, my lord, it gets matted, and that is what is called as a dreadlock, my lord.
Jata in Sanskrit.
Yes, my lord. Yes, Jata,
Yes.
you're right. Another is that, kindly see this, my lord. The Rastafarian women should cover their heads. And my lord, she was prevented from covering the head. And my lord, on the ground of uniform. And my lords, the court in para 16 and 17, my lord, says this. I have sought in vain to find these principles clearly enunciating the code of conduct to which the applicant was subject. That does not, of course, mean that they do not have a role to play in the interpretation and application of the code of conduct. Even if hypothetically, the growing of dreadlocks and the wearing of headgear were prohibited by the code of conduct, that is the school's code of conduct, the failure to comply with this prohibition should not be assessed in a rigid manner. If I can request the camera had gone off. This would make nonsense of the values and principles set forth in the schedule and would bring it in conflict with justice, fairness, and reasonableness which underpins our new constitution and centuries of common law. The question should be asked in this regard is whether or not the prohibition is aimed at promoting positive discipline, or whether or not compliance therewith
Non-compliance. No, non-compliance.
Non-compliance therewith justifies punishment or some other form of sanction. This requires a spirit of mutual respect, reconciliation, and tolerance. The mutual respect in turn must be directed at understanding and protecting rather than rejecting and infringing the inherent dignity, convictions, and traditions of the offender. So that's how beautifully put. Not here assuming that there is a uniform. Somebody is asking for an exemption. The duty of the state and the school is to accommodate that person, not to punish. Now, my lords, the next judgment, I'll be quick, my lord. And this, I think, my lords, is really the Gita. As far as, my lord, how a constitutional court faced with a dilemma of competing interest, namely a student's right of practicing his faith, countered with the competing interest of the school in maintaining uniformity and, my lords, a certain degree of discipline. What is the, my lord, delicate balance which your lordships have to, my lord, embark upon? Very difficult, my lord, and a beautiful judgment of the Constitutional Court of South Africa will probably guide this, my lord. Just have a look at, my lord, the next judgment by the Constitutional Court of South Africa, MEC for Education, my lord. Sorry, this is Fiona 9, governing body.
This judgment is rendered in the light of the text of the constitutional provision. How that constitutional provision reads.
Straight away, my lord. That is why I wanted to cite the Constitutional Court. Just if my learned colleague can hand over Navneet Fiona Knight versus Navneet Pillai. All the provisions of the Constitution are noted. I'm extremely grateful for that question, and that will be answered by this judgment. Lord, when the thing is being handed over, I will just explain, my lord, what are the facts. The facts pertain to, my lords, a Hindu girl named, my lords, Pillai. And, my lords, she was from South India. And she wanted to wear a nose ring, my lord. This entire 200-page judgment is based, my lords, on whether she had a right under Hindu law to wear or Hindu faith, my lord, to wear a nose ring, because the school said, look here, we can't permit this. And the argument which was raised was, and very interesting, my lord, the argument of the school was that it will lead to a parade of the horribles. Parade of the horrible. That's the argument. That everybody would be wearing some nose ring, somebody would be wearing a cap, somebody would be wearing something else. And how the court dealt with it. Just have a look at, my lord, paragraph 1. It's by Langa, Chief Justice of the Constitutional Court. What is the place of religious and cultural expression in public schools? This case raises vital questions. I'm sorry, my lord, Justice Dixit got it.
Which paragraph?
First paragraph.
First, I'm reading para 1, my lord. I'm sorry, my lord. Para 1.
Yes.
My lord, Justice Kazi also got it.
Yes.
My ladyship got it. Para 1.
Yes, sir. Okay.
Yes. What is the place of religious and cultural expression in public schools? This case raises vital questions about the nature of discrimination under the provisions of the Equality and Prevention of Unfair Discrimination Act, as well as the extent of protection afforded to the cultural and religious rights in public school setting and possibly beyond. At the end, at the center of the storm is a tiny gold nose stud. So that's the center of the controversy. Now, my lords, may kindly turn to paragraph 11. How the case came, my lord, before the Constitutional Court. The Equality Court hearing, para 11. The issue before the Equality Court was whether the school's refusal to permit Sunali, the girl's name was Sunali Pillai, my lord, Sunali, to wear the nose stud at school was an act of unfair discrimination in terms of the Equality Act. The evidence presented by Ms. Pillai amounted to the following. The practice of wearing the nose stud is a tradition that is some 4,000 to 5,000 years old, hailing predominantly from the south of India. When a girl comes of age, a stage marked by the onset of her menstrual cycle, the family honors the fact of becoming a young woman. As a part of the ritual, a prayer is performed, the nose is pierced on the left side for the insertion of the nose stud. The ritual also serves the purpose of endowing daughters with jewelry, since a woman's dowry in patriarchal society went to her husband, and all she could claim as her own was her jewelry. Further, according to Ayurvedic medicine, this is very interesting, the medicinal branch of Vedas, the left side of the nose is directly related to fertility and childbearing. Ms. Pillai stressed the practice of wearing nose stud or ring plays an important part in many religions and is not limited to Hinduism. On the other hand, Hinduism is a variety of sects that observes various different practices. So this was her case, my lord. Now, my lord, at para 20, the High Court, my lord, when the matter went to the High Court, para 18, the High Court set aside the order of the lower court and replaced it with an order declaring null and void the school's decision prohibiting the wearing of a nose stud in school by Hindu learners. The school now applies for leave to appeal to this court against the decision of the Pittsburgh High Court. Now, my lords, may kindly turn to para 26. This is the argument of the school. And that is what, my lord, will be contended by the schools and the state here. It was further contended that in the event of it being found that there was discrimination against Sunali, such discrimination was not unfair. In that context, the applicants pointed out to a number of factors, namely that the code was compiled on the basis of prior consultations with all relevant parties. Ms. Pillai had agreed to the code. The popularity of nose studs outside of Sunali's culture, the importance of uniforms in maintaining discipline, the need to give deference to school authorities, and the fact that the ban on wearing of a nose stud would only have a limited effect on Sunali's culture, since she was at liberty to wear the nose stud when she was not at school. This is the argument. What will happen to you if you remove the hijab for a few hours in school? Heavens are not going to fall. Same argument, my lord. And that is considered, my lord, in para 35. My lords, what Justice Latham said, my lords, in paragraph 35, your lordship's Justice, my lord, told me on the first day, and I found it very interesting. Just have a look at paragraph 35. Exactly the same what your lordships told all of us on the first day. As already noted, this matter raises vital questions about the extent of protection afforded to cultural and religious rights in the school setting and possibly beyond. These issues are both important and complex, as is evidenced by the varying approaches of the courts below, as well as in foreign jurisdictions. Extensive argument has been presented, not only from the parties, but from the three amicus curiae. Interestingly, some Hindu institutions, my lord, were asked to assist the court. And then, my lords, they grant leave to appeal. And the consideration, my lord, starts from paragraph 46. And that will answer, my lord, Justice's question on what was the fundamental rights regime in that case. Para 46, my lord, running page 22, which your lordships will find in the bottom. The prohibition of discrimination on the basis of religion or culture in terms of the Equality Act and section 9 of the Constitution is distinct from the protection of religion and culture provided by section 15 and 30 of the Constitution. And section 50, my lord, lordships, 15, there is a footnote. Everyone has the right of freedom of conscience, religion, thought, belief, and opinion. The two rights may overlap. However, where the discrimination in question flows from an interference with a person's religious or cultural practices. Therefore, in order to establish discrimination, notice I was reading over the page, Miss Pillai must show that in some way the school interfered with Sonali's participation in practice of or expression of a religion or culture. The inquiry is similar to an inquiry under section 50 or 30. Then, my lords, they outline the scope of inquiry, and my lords, in paragraph number 50, they talk about, my lord, Sonali being a part of South Indian Tamil culture, para 50, and then, my lords, in paragraph 53, and this I really, my lord, I was really awestruck, my lord, by this paragraph, and it is quite similar, my lord, to our Hindu philosophy. Just have a look at, my lords, para 53. Firstly, cultural convictions or practices may be as strongly held and as important to those who hold them as religious beliefs are to those more inclined to find meaning in a higher power than in a community of people. The notion that we are not islands unto ourselves is the central to the understanding of the individual in African thought. Your lordships are very well aware, my lords, of our scriptures. Our scriptures, my lord, Vedas, Upanishads, the central theme is, my lord, we are not islands. And we are all linked, my lord, in some form or the other by a superior force. And that is what, my lord, finds echo even in, my lord's, distant African lands is what I thought, my lord, was quite astonishing. It is often expressed in the phrase, Lord, I will avoid saying that because I can't, my lord, probably do justice to that word, which emphasizes communality and the interdependence of the members of the community, and that every individual is an extension of others. Kindly see this, my lord. According to Geek, an individual human person cannot develop and achieve the fullness of our potential without the concrete act of relating to the other individual persons. This thinking emphasizes the importance of the community to individual identity and hence to human dignity. Dignity and identity are inseparably linked as one's sense of self-worth as defined by one's identity. Cultural identity is one of the most important parts of a person's identity precisely because it flows from belonging to a community and not from a personal choice or achievement. And belonging involves more than simple association. It includes participation and expression of the community's practices and traditions. Then, my lords, paragraph 60. As far as this practice is concerned, Lord, the court says, the evidence shows, Lord, there is an equal. In conclusion, if I can request others to mute, I think there is an echo, the court will be disturbed, I think. In conclusion, the evidence shows that the no stud is not a mandatory tenet. Kindly see this, my lord, of Sonali's religion or culture. Miss Pillai has admitted as much. But the evidence does confirm that the no stud is a voluntary expression of South Indian Tamil Hindu culture, a culture that is intimately intertwined with the Hindu religion, and Sonali regards it as such. So same as, my lord, what Bijoy Emmanuel, Justice Chinnappa Reddy said, you have to see it from the point of view of the believer. Not same thing is echoed here. The question arises whether the no stud should be classified as a religious or a cultural practice or both. This court has noted the temptation to force grounds of discrimination into neatly self-contained categories should be resisted. That is particularly so in this case, where the evidence suggests that the borders between culture and religion are malleable, and the religious belief informs cultural practice, and cultural practice attains religious significance. As noted above, that will not always be the case. Culture and religion remain different, so on and so forth. Then, my lord, in the court goes on to say, my lord, that's mean just make a note of the paragraphs, that even a voluntary practice, which is a part of a culture, will, my lords, be protected under the freedom of conscience clause. That, your lordship, since I'm not troubling your lordships may make a note, para 60 to 67. Just make a note, my lord. I don't want to trouble your lordships. I'll only read the important conclusions. Then, my lord, the argument of the state is dealt with, and that is in paragraph 73. But what is the content of this principle? At its core is the notion that sometimes the community, whether it is the state, and I'm sorry, my lord, Justice Dixit got it, my lord?
No, which paragraph?
Para 73, my lord, I'm sorry. 73, running page 38. 38, my lord. Yes. What is the content of the principle? At its core in the notion that sometimes the community, whether it is the state, an employer, or a school, must take positive measures and possibly incur additional hardship or expense in order to allow all people to participate and enjoy all their rights equally. It ensures that we do not relegate people to the margins of society because they do not or cannot conform to certain social norms. And then, my lord, kindly turn to paragraph 85. Because what para 73 seems to suggest, my lord, is that we have to give a certain degree of accommodation, my lord. Para 85, the school submitted, and this is, my lord, really interesting. The school submitted that the infringement of Sonali's right, if any, is slight, because Sonali can wear the no stud outside the school. And Chief Justice says, I do not agree. The practice to which Sonali adheres to is that once she inserts the no stud, she must never remove it. Preventing her from wearing it for several hours of each day would undermine the practice and therefore constitute a significant infringement of a religious and cultural identity. What is relevant is the symbolic effect of denying her the right to wear even for a short period. It sends a message. Only see this, my lord. It sends a message that Sonali, her religion, and her culture are not welcome. Because I don't want to say anything more. See how beautifully the court puts it, my lord. That you can't send a message to someone in the community, my lord, that it out because it sends a message that a particular, my lord's religion or a culture is not welcome. And that should not be the approach of the court. The school further argued that no study is not central to Sonali's religion or culture, but is only an optional practice. I agree that centrality or practice of a belief must play a role in determining how far another party must go to accommodate that belief. The essence of reasonable accommodation is an exercise of proportionality. So, my lord, here Article 14 comes in. Persons who merely appear to adhere to a religious and cultural practice, but who are willing to forego it if necessary, can hardly demand adjustment. Not exactly the shall argument, my lord. The same adjustment from those whose identity will be seriously undermined if they do not follow the belief. Just see this, my lord. Persons who merely appear to adhere to a religious and or a cultural practice, but who are willing to forego it if necessary, can hardly demand the same adjustment from others as those whose identity will be seriously undermined if they do not follow their belief. The difficult question is how to determine the centrality. Should we inquire the centrality of the practice or belief of the community or of the individual? While it is tempting to consider the objective importance of or centrality of a belief to a particular religion or culture in determining whether discrimination is fair. My Lord Justice Dixit got para 87, my Lord? Yes.
Yes, sir.
In my view, courts should not involve themselves in determining the objective centrality of practices, as this would require them to substitute their judgment of the meaning of a practice for that of the person before them, and often to take sides in bitter internal disputes. That's the same approach Bijoy Emmanuel. Also, my lord, I showed our Shirur Math. Those judges didn't have the benefit of these Western countries, but they said it, my lord. Outside authorities should not determine. Judges should not determine. It should be understood from the point of view of the believer. The same thing, my lord, what Chief Justice Langa says, my lord. This is true both for religious and cultural practices. If Sonali states that the no stud is central to her as a South Indian Tamil Hindu, it is not for the court to tell her that she is wrong because others do not relate to that religion or culture in the same way. Our court said this 50 years back, my lord. The same thing is echoed. Now see this para 88, my lord. Centrality must be judged with reference only to how important the belief or practice is to the claimant's religious or cultural identity. In reaching the decision, the court can properly look at a range of evidence, including the evidence of objective centrality to the practice of the community at large. That evidence, however, is not only relevant insofar as it helps to answer the primary inquiry of subjective centrality. The fact that a practice is voluntary may also be relevant, as many people will not feel that voluntary practices are central to their religious or cultural identity. But there will be those, although they do not feel obliged to observe a certain practice, feel that it is central to their identity that they do so. They too deserve protection. In sum, the school and this court must consider all the relevant evidence, but the ultimate question is how central is the no stud to Sonali's religious and cultural identity. However, the need for a subjective investigation takes us back to the complaint. Then, my lord, just one or two paragraphs more. Para, my lords, 8. My lords, I'm sorry, para 95.
Where is the ratio of this judgment?
Yes, my lord, the conclusion is in para 112, where, my lords, they hold that this expulsion cannot be sustained. But before that, my lord, if I can just place a few paragraphs. the effect on the school. It is no doubt true that even the most vital practice of religion or culture is needed for the greater good. Our public health, my lord, public order, morality, and my lord's health. My lordships has para 95, my lord. I'm sorry, my lord, para 95.
Yeah, it's no doubt true.
Yes, my lord. Can be limited for the greater good. So they discuss what is the greater good. No belief is absolute, but those are the closer core of an individual's identity, requiring a greater. I'm sorry, my lord. Page 5. I'm so sorry, my lord. The lordship's pardon.
Yes.
Para 95, my lord. It is no doubt true that even the most vital practice of a religion or culture can be limited for the greater good. No belief is absolute, but those that are closer to the core of an individual's identity require a greater justification to the limit. The question is whether, considering the importance of the stud to Sonali, allowing her to wear the stud would impose too great a burden on the school. The primary argument of both the school and the GBF, whether allowing Sonali to wear the no stud or allowing others like her similar exemptions, would impact negatively on the discipline of in the schools, and as a result on the quality of education they provide. This evaluation is correctly characterized by Ms. Pillai as relating to the factors under 14.3 so and so. Then, my lord, kindly see para 98. Both discipline and education are legitimate goals. However, care must be taken not to take the school's interest too broadly. Sonali's interest in wearing her nose stud could never outweigh the general importance of ensuring discipline in schools. The interest of the school must be confined in refusing Sonali an exemption not to wear the uniform in general. But this case is not about uniforms, but about exemptions to existing uniforms. Kindly see, my lord, how aptly put. This case is not about, my lord, saying that there should be or there should not be a universality of uniforms. This case about whether certain people should be exempted from the rigors of a uniform. And in this particular case, not even an exemption, just an additional, my lord, a headscarf of the same color. So, my lord, this entire debate that my lord, the petitioners before your lordships are wanting to do away with the uniform regime, or that, my lord, the court is called upon to decide the validity of uniforms, my lord, that is not the issue at all. The issue is about exemption and whether that exemption is a reasonable thing to ask. Then, my lord, kindly turn to the importance of discipline, my lord, and it's very beautiful. I'll not trouble your lordship, but whenever lordships have time, lordships can see paragraph 90. Lordships may make a note. 99 is very important, my lord. That's the argument of the schools. Rules are important. Discipline is important. And then, my lord, para 101. And in fact, my lord, paragraph 100, the judge takes great care, my lord, to say nothing in this judgment should be interpreted as encouraging or condoning the breaking of school rules. And then, my lord, para 101. But this case, my lord, page 52, my lord, the Chief Justice got it, my lord?
Yes.
Yes. But this case is not about the constitutionality of school uniforms. It is about granting religious and cultural exemptions to an existing uniform. The admirable purpose that uniform serves do not seem to be undermined by granting religious and cultural exemptions. There is no reason to believe, nor has the school presented any evidence to show, that a learner who is granted an exemption from the provisions of the code will be any less disciplined, or that she will negatively affect the discipline of others. So, my lord, this is, my lord, I am respectfully urging for your lordship's kind consideration. This case, my lord, is not a case about constitutionality of school uniforms. This case, my lord, is that whether, my lord, certain leeway, a certain exemption, a certain, my lord, degree of accommodation can be given to students, my lord, exercising the religious faith, and, my lord, a little modification is what, my lord, students are asking for. Then, my lord, they discuss this test from 101, 102. Yeah. I am therefore not persuaded that refusing Sunali an exemption achieves the intended purpose. Indeed, the evidence shows, I'm grateful for my learned friend, my lord, I missed this. Indeed, the evidence shows that Sunali wore the stud for more than 2 years without any demonstrable effect on school discipline or the standard of education. This is what the Honorable Chief Justice put to me. Have you been wearing this headscarf? And I said, yes, this is my statement in the petition. And till today, my lord, till the issuance of the circular and the GO, people, students were wearing a headscarf. They were, my lords, following the school discipline. Granting exemption will also have the added benefit of inducting learners into a multicultural South Africa where vastly different cultures exist side by side. Very beautifully put, my lord. Then, my lords, the last paragraph which I want to cite is very interesting, 107. And this is the, my lord, parade of horribles argument. Para 107, page 54. The other argument raised by the school, my lord, last paragraph, my lord, of that page 54, my lord. My lord,
Yes, sir.
yes. The other argument raised by the school took the form of a parade of horribles or slippery slope scenario that the necessary consequence of a judgment in favor of Miss Pillai is that more learners will come to schools with dreadlocks, body piercings, tattoos, and lion cloths. The same argument, my lord, which is being raised today, that look here, if you permit this, tomorrow you have people walking along. I'm sorry, my lord.
Not 6.
Can I read it again, my lord?
Please read 106 fully.
Yes, sir. Asserting that no stud should not be allowed because it is also a fashion symbol fails to understand its religious and cultural significance, and it's disrespectful of those for whom it is an important expression of their religion and culture. I'm grateful, madam. In addition, to uphold the school's reasoning would entail greater protection for religion or cultures whose symbols are well known. Those are, in fact, often the ones least in need of protection. I'm grateful, madam. It would also have the absurd result that if a turban, yarmulke, or a headscarf becomes part of popular fashion, they would no longer be constitutionally protected, while they have constitutional protection as long as they remain fringes on the society. I accept the popularity of the no stud may make it more difficult to determine if a learner is practicing her religion or culture or trying to impress her friends. But once the former is established, as it has been in this case, the mainstream popularity of a religious or cultural practice can never be relevant. Not this is what I was saying. Not the essence of 25 is the innocent practice of faith, not, my lord, a display of religious identity. And what the court says that it is not a display of fashion. And then, my lord, para 107 is what I was commending for my lord's kind consideration. The other argument, my lord, Justice Dixit got it, my lord, para 107. Yes.
Yes.
The other argument raised by the school took the form of a parade of horribles, a slippery slope scenario that the necessary consequence of judgment in favor of Miss Pillai is that more learners will come to school with dreadlocks, body piercing, tattoos, and lion cloths. This argument has no merit. Firstly, only see this, my lord. This judgment applies only to bona fide religious and cultural practices. It says little about other forms of expression. The possibility of abuse should not affect the rights of those who hold sincere belief. Secondly, if they are other learners who hitherto were afraid to express their religions or cultures, and who will now be encouraged to do so, this is something to be celebrated, not feared. So, my lord, what the court says is that somebody has a genuine, my lord, practice of faith. He wants to wear a nama, he wants to wear a rudraksha. My lord, that should be celebrated and not feared. As a general rule, the more learners feel to express their religions and culture in school, the closer we will come to the society envisaged in the constitution. The display of religion and culture in public is not a parade of horribles, but a pageant of diversity, which will enrich our schools and in turn our country. Thirdly, acceptance of one's practice does not require the school to permit all practices. If accommodating a particular practice would impose an unreasonable burden on the school, it may refuse to permit it. So, my lord, therefore, I respectfully submit, my lord, that considering the principles which have been laid down in this judgment, and my lord, which has been followed by our Supreme Court, the wearing of a headscarf is such an innocuous practice and which is completely protected by Article 25. Now, my lords, I have finished South Africa, and I'll just run through my lord, a few other jurisdictions.
We just want to remind you that yesterday you said you will only take 10 minutes.
But since the question had come from your lordships, so, my lord, I will finish today, my lord. I will finish today. I will finish today. I promise that, my lord. I'll finish today.
But my lord, there are half a dozen more petitioners who are supposed to argue, my lord.
That's okay. I have a right to finish. I'll finish it today.
You can argue till academic year comes to an end.
15 minutes.
No issue.
Yes, my lord.
We are not in a hurry.
Yeah, but you
We are
should
not in a hurry, but you should be in a hurry.
Yes, my lord. I'll be in a hurry, my lord. I have not repeated, my lords. Lordships may cut me down if I repeat any argument. My lord. I have not repeated any single argument.
Yes. Yesterday you wanted only 10 minutes.
My lord, since the questions fell from the honorable court, I thought it was my duty, my lord, to answer it. Lords, I will finish it, my lord. I will finish it today. Lords, just grant me that indulgence. Lords, I'll finish it, my lord. Lordships have been very patient with me. I will finish it, my lord. My lords, the next judgment which I want to cite is from Canada, and I will not cite paragraphs after paragraphs. This was a judgment, my lord.
How these judgments are relevant for the issues involved here in the context of the Constitution of India.
Correct, my lord. Correct. I bow down, my lord. But since a question had come from your lordships that how this secular practices, my lord.
Yesterday you cited a judgment where a Malaysian court was cited,
Correct, my lord. Correct.
reported.
Yes.
Therefore, the courts ask you
Yes,
a question whether it is a central court.
Lords, I will not trouble your lordships. What I'll do, my lord, I'll give a 1-page or 2-page note having all these judgments of various jurisdictions.
That will be better.
I agree. But lordships will make a note. Just make a note. Lord, just make a note. I'll give the citation. I will not cite it. Lordships will just make a note. I will not recite the judgment. My lord, sir, this is Supreme Court of Canada, 2006 1 SCR, page 256. And here the issue was, my lord, whether a school student wearing a kirpan to a school infringes the student's freedom of religion. They said it does, and it should be permitted. That is, my lord, 2006 1 SCR, page 256, Canada, my lord. The next judgment, my lord, which I want to cite is a House of Lords judgment from England, and that is, my lord, 2006 UKHL 15. And my lords, this judgment, lords, I have to fairly say, this judgment prohibited, my lord, and upheld the right of the school to, my lord, say that a student should not be permitted a full dress, what they call a jilbab. And that I wanted to cite as an officer of the court, my lord. I have to cite. But I also have to tell your lordship that this judgment noticed the fact that that school had permitted students from the Muslim faith to have a headscarf. And therefore, they say it was a reasonable allowance being made, but we cannot go to the extent of disturbing the other students by permitting the entire attire to be changed. they permitted headscarf, but not jilbab. That is, my lord, 2006 UKHL, page 15. So these are the three judgments, my lord, which I wanted to cite from, my lord, common law jurisdictions. My lord, coming
Yes.
back, my lord, I was on public order, and I was, my lord, on the judgment that the state cannot just say, my lord, that public order will be disturbed, and therefore we will restrict your freedom. And I was inviting your lordship's attention to 1982 1 SCC page 71, where I stopped yesterday. Just have a look at that judgment, which is at, my lord, page 81 of compilation number 1. Compilation 2. Expired compilation. And just one paragraph, my lord, at page 1. But somewhere in the 8 lines from the end of that paragraph, having elaborated the principles which should guide the exercise of that power, we hope and trust that in future power will be exercised by the executive magistracy in defense of such established rights. My lord, Chief Justice, got it, my lord?
Paragraph?
Paragraph?
33, my lord. I'm sorry, para 33. Page 123, my lord. Running page 123.
123.
123, my lord. Having, my lords, about 8 lines from the bottom of para 33, having elaborated the principles which should guide the exercise of that power, we hope and trust that in future power will be exercised by the executive magistracy in defense of such established rights of the petitioner and the Shia community, and instead of prohibiting or suspending the exercise of such rights on concerned occasions on the facile ground of imminent danger to public peace and tranquility of the locality, the authorities would make a positive approach to the situation and follow the dictum of Turner, Chief Justice, that if they are satisfied that the exercise of the rights is likely to create a riot or breach of peace, it would be their duty to take from those whom disturbance is apprehended security to keep the peace. After all, customary rights by the petitioners, Director of Fundamental Rights, guaranteed under Article 25 and 26 of the Constitution to religious denomination who are desirous of so and so many. Then, my lord,
You were disconnected. We could not hear you. You
I'm
are
sorry,
on
my
which
I'm
paragraph?
sorry. Lord, I
Which-
was on paragraph 33, my lord. I'm sorry.
Yes.
Not the last about 6 lines of that paragraph. Lord, you have marked it. What it only says, my lord, that the state cannot just take a facile ground of public order. It has to create a positive environment to facilitate exercise of fundamental rights. That's what it says, my lord. Lord, you may go through it. My lord, the next judgment which I want to cite, and this is the latest one, which is, my lord, of Justice Chandrachud, 2020 12 SCC page 436, which is at page 127, my lord, of this compilation. Just one paragraph, my lord. Para 50. Lordships may also note paragraph 46, 47. I will not read it, but make a note, my lord, para 46, 47, where, my lord, Justice Chandrachud, my lord, talks about the growing intolerance about not accepting the rights of others. And in paragraph 50, he says, my lord, between Placidum F and G, 156, paragraph 50, between F and G in its capacity as a public authority, and this is what I commend for my lord's kind consideration, page 156, para 50, between placetum F and G, in its capacity as a public authority enforcing the rule of law, the state must ensure that conditions in which the freedoms flourish are maintained in the space reserved for free exercise of speech and expression. The state cannot look askance when organized interest, kindly see this. I'm sorry, the Chief Justice got it.
Yes.
156. 156.
Between placetum F and G.
Yes.
Para 0. Between placetum F and G. In its capacity as a public authority enforcing the rule of law, the state must ensure that the conditions in which freedoms flourish are maintained in the space reserved for the free exercise of speech and expression. The state cannot look askance when organized interest threaten the existence of the freedom. State is duty bound to ensure prevalence of conditions in which of those freedoms can be exercised. The instruments of the state must be utilized to effectuate exercise of that freedom when organized interest threaten properties of theater owners or viewing audience with it is the plain duty of the state to ensure speech is not silenced by the fear of the mob. Unless we read a positive obligation on the state to create and maintain conditions in which freedoms are guaranteed by the Constitution, there is a real danger that art and literature would become victims of intolerance. So, my lord, the state says if somebody wears a headscarf, there will be galata. Therefore, we are stopping everything. Can't be the reasoning. My lords, I will not trouble your lordships with more judgments. If your lordships can just have my written arguments, I'll just finish in 10 minutes, my lord. I have quoted everything. Just have a look at, my lord. My lords, the judgments which I cited, my lord, of Ghulam Abbas and Justice Chandrachud's judgment, my lord, in this indelibly 2020, according to me, my lord, give judicial recognition to the American doctrine of heckler's veto. Lordships may make a note of that. Heckler's veto is this, my lord, that I go on the street, I want to exercise my freedom. Somebody comes and doesn't like Devdutt Kamat's face and says, threatens me, how are you coming to the street? State says that, look here, yes, Devdutt Kamat cannot go on the street because somebody else doesn't like, it may create trouble. So courts have taken the view, a heckler cannot be allowed to veto a fundamental right. And that's the heckler's veto doctrine. And according to me, my lords, Ghulam Abbas Ali and Justice Chandrachud have in India recognized that doctrine. And therefore they say that there has to be a positive obligation on the part of the state to create a situation for enforcement of fundamental freedoms. And those heckler's veto judgments, my lord, lordships will just make a note in my written note, page 14, my lords, para 30, 31 and 32. Three US Supreme Court judgments I have cited, which I will not repeat, my lord. Just make a note, para 30, my lord. Para 30 is one judgment, 31, 32, 15 to 16, my lord. 14, 15, 16. Then lordships kindly come to para 17, page 17, my lord. Lords, page 17, my lord, one of the arguments is, and that your lordships also, my lord, that order which your lordships passed on last Thursday, that nobody shall disclose any religious symbols. Lord, in our secular state, probably what your lordships had in mind, that nobody should display religious symbols. And that's what the state says. But our secularism, my lord, is not, my lord, Turkey secularism. Our secularism is positive secularism, where, my lord, the state plays an enabler role for the exercise of fundamental rights, religious freedoms of all communities. We recognize all religions as true. And that is what, my lord, I have explained at page 17, para 36. Justice Shah's judgment, my lords, in Aruna Roy. Lordships have page 17, my lords, of my written note. Para 36. The Indian interpretation of secularism stems from the Vedic percept of Sarva Dharma Samabhava. In this regard, attention is invited to Aruna Roy, and kindly see, my lord, the quoted portion in para 8. I'm sorry, my lord. Yes.
Page 13.
1-3.
In our
Page 1-3.
written submission, it is on page 13, para 36.
Yeah, I'm sorry, my lord. I'm sorry. Para 36, my lord. I think there is some page numbering problem. I'm so sorry, my learned friend. It's my mistake, my lord. Para 36, my lord. My lords, para 86 of Aruna Roy is quoted, and if your lordships have the highlighted portion, secularism, therefore, is susceptible to a positive meaning, that is developing understanding and respect towards different religions. The essence of secularism is non-discrimination of people by the state on the basis of religious differences. Secularism can be practiced by adopting a complete neutral approach or by a positive approach, by making one section of religious people to understand and respect the religion and faith of another person. Based on such mutual understanding and respect for each other's religious faith, mutual distrust and intolerance can be eliminated. Notice what I am submitting is this. The state says that we are a secular state. We are not Turkey, my lords, where there is, my lord, negative secularism, where the state says that nobody shall display religious identity in public. That hijab ban was upheld, my lord, by that Turkish court, went to the European court, which was upheld. But their constitution is completely different. Our constitution is positive secularism, where, my lords, if we practice different faiths, that has to be recognized, that religious identities have to be recognized. Then, my lord, I have enumerated that I finished 25, my lord. That let's leave aside 25. Now, this is a innocuous practice of wearing a headscarf and not changing my uniform. And I say, my lord, this is a facet of the freedom of speech and expression. A reasonable restriction would be, my lord, that everybody wears a uniform, no difficulty. But a small exemption, if it is given of wearing a headscarf, Lord, I would say, my lord, that is in line with expressing that freedom. And that's what the Supreme Court said, my lord, that personal appearance, well, I've cited that case in para 37, my lord, where I've said that freedom of appearance is part and parcel of Article 91A. And similarly, my lord, in paragraph 38, I have put it on the anvil of Article 21. I will not repeat, my lord. Puttaswamy judgment I have cited. And lastly, my lord, I have also put it on the ground of, my lord, Article 29. Because Muslims, my lord, will be protected under Article 29, being a religious minority, my lord, and at 29(2) as a cultural minority. And then, my lord, paragraph 44 onwards, what may really not arise for consideration in view of the others. Now, that was a situation before the learned single judge, where, my lord, these students were made to sit separately. And the question was, my lord, whether that violates Article 14. My lord, there I have said, my lord, that the segregation business, where putting Muslim students separately, wearing Hindu students separately, my lord, wearing hijab separately, that is completely destructive of our right to equality. That I have placed all those judgments also. And the last one, my lord, which I want to cite, last proposition, my lord, para 52. Mr. Hegde has argued this, my lord, that I say that under the provisions of the Education Act, my lord, there is no power lots of the state to prescribe or to have this GO, and I have cited section 7, my lord. Section 7 is for prescription of syllabi, etc. My lords, the argument which I want to make on this Education Act is this, and please, my lord, this is a demurrer argument. The demurrer argument is this: assuming you have the power to enforce a uniform, assuming that Muslim students, my lord, wearing a hijab cannot be given an exemption. Then I ask, my lord, where is the power to expel students from a school because they are not prescribing to that uniform? I can understand, my lords, people are wearing different uniforms, a disciplinary code. Wearing an extra, my lord, attire in the form of a hijab, and the school expels them. I submit, my lord, the doctrine of proportionality will come in. The lordship will have to examine this. This is not a case, my lord, where a student goes and fights with somebody and you expel him from a school or suspend him from a school. He is just asserting his religious rights under 25 and other fundamental rights. And you say that, look here, there is a uniform policy. There is an act which says that Rule 11 says that there is a uniform, and therefore, if you don't wear a uniform, I'll expel you. But expulsion has severe consequence in administrative law. Lordships are very well aware. I don't need to cite judgments. Doctrine of proportionality will come in, and therefore, my lords, I end.
In your case, the students have been expelled.
No, my lords, I am saying they're not allowed to come. It has the same effect.
Different.
Students not being permitted to attend class.
Not Mr. Kamath, but Honorable Chief Justice. Honorable Chief Justice.
They are not expelled.
Expulsion is one thing. Not permitting to gain entry to the institution is another.
Absolutely. Lords, my case is the second. My case is the second. That institution.
Doctrine of proportionality, when in case they have not been expelled, how you are applying the doctrine of proportionality?
I am grateful for that question. I'll
If a
answer
passenger is not permitted, 1 second, Mr. Kamath. If a passenger is not permitted to gain entry to a train because he does not have a ticket, that's not a case of expulsion.
I bow down. Lords, it's my mistake. I used the wrong word. Lords, I'm sorry. I used the wrong word. They have not been permitted to come inside. And this is not a case, my lord. This is not a case, with greatest of respect, of a my lord's passenger alighting a train. My lord, this is the case where a student, apart from other fundamental rights, my lords, 14, 19, 21, 25, 29, is wanting to access education, which is also a fundamental right under 21. And the state says, my lord, that we will not permit you inside the school. And in that context, my lord, I raise the doctrine of proportionality. Is the action of the state proportionate to what? That's the
It is whether the has not been allowed inside the class or inside the school.
Inside the classroom. Yes, my lord. I am saying either which way, either inside the classroom or school, both have the same, my lords, legal consequences. Now, in that context, my lord, I end with this, my lord. Just have a look at your lordship's order, which your lordships passed, my lord. The detailed order which your lordships passed on Thursday. Probably, my lord, we were not in a position to assist your lordships that because of paucity of time and certain observations here, my lord. I respectfully submit.
By that order, nothing was decided.
Nothing was decided. Whatever your lordships say, my lord, whatever
was decided.
Go down, my lords. Whatever your lordship says, my lord, as a constitutional court, my lord, has great significance, has great value, my lord, to citizens of this country. Now, kindly see paragraph 8. Firstly, we are pained by the ongoing agitations and closure of educational institutions since the past few days, especially when this court is seized of this matter, and important issues of constitutional significance and personal laws are seriously being debated. Absolutely correct, no. It hardly needs to be mentioned that ours is a country of plural cultures, religions, and languages. Being a secular state, it does not identify with any religion of its own. Every citizen has a right to profess and practice any faith of choice is true. However, such a right, not being absolute, is susceptible to reasonable restrictions. Now, Lords, this in my respectful submission is against the Constitution. Why I say this, my Lord? Because Article 25, there is no concept of reasonable restriction, my Lord. Article 25 is subject only to public order, morality, and health, my lords. Number one.
Not
Or, my
reasonable.
lords, the law of social
Then those are the restrictions.
Do you say that they are
my
restrictions?
lords, I'm making a submission. Lordships may want to, my lords, have a different view. According to me, my lord, this
Yesterday
reasonable
we
restriction.
pointed out how the article starts.
Subject to.
Yes, Lord, I
Subject.
hold on. Yes.
Yes.
Yes. Then lastly, my lord, just have a look at the operative portion. Pending consideration of these petitions, we restrain all students, regardless of their religion or faith, from wearing saffron shawls, scarves, hijab, religious flags, or like within the classroom until further orders. I respectfully submit, my lord, the sweep of your lordship's order is, my lord, extremely broad. But I say that it is in the teeth of Article 25, my lords, and also other constitutional rights. And my lords, kindly make some leeway. Lordships are examining, my lord, issues of, my lords, grave constitutional significance of seminal importance. In the meanwhile, my lords, please permit us to, my lord, carry out this innocent faith, subject to whatever conditions your lordships may impose. We will have the same, my lords, uniform. We will, my lords, just wear an additional headscarf. Because this consideration is going to take time, my lords. My learned friends, my lord, you lordships will have the benefit of erudite, my lord, submissions. The best counsels, my lord, are going to assist your lordships. So therefore, my lord, I respectfully submit this order, in fact, my lord, suspends fundamental rights. Please don't, my lords, continue this order from today, my lord, is my respectful submission. Lords, I bow down to your lordships for having heard me patiently, my lords. And I part, my lord, by also, my lord, mentioning that my friends, my lord, Nishan Patil, Nizam Pasha, my lord, and Shahul and Nias have contributed immensely to the research, my lord, which has been placed before your lordships. And I am only the mouthpiece of their hard work, my lord. I'm grateful for a very patient hearing, my lord. Grateful, my lord.
Okay. Thank you.
Lords,
I am also making one submission with my lord's permission, my lord.
Item number 1, that is 2347. In continuation with what has already been submitted. I think, I believe that I stand in front of the law which your lordship designed yesterday.
You are in which case? 2347?
Yes, 2347. The next impleading petition in support of
My lord, may I kindly
I will submit is this. I won't be taking time. I will be shortening myself by making a proposition. This is my point, my lord.
With respect, may I make the submission? I am appearing for the petitioners in writ petition 2347.
2347, already submissions have been made by Mr. Kamath.
Sanjay Hegde.
Like 234.
My lord, I appear, my lord, in the first petition, my lord.
2347 has not been argued, if I may say so.
Mr. Hegde submitted in 2146.
No. My lords, I appear in my lords 2146, my lords, which is the first petition in the line of the order.
1.1 is.
My lords, in fact, the 6 petitioners, these are the first 6 girls.
Just let us first understand who is appearing in which case.
My lords, the first petition which was filed before the honorable single
Wait
judge.
for some time, Mr. Mir, please wait. 1.1.
1.1 argued by Mr. Sanjay Hegde.
2146.
2146.
Mr. Sanjay Hegde.
1.2 WP.
Just a minute. 1.2.
1.2, that is WP 2880 of 22. 2880. 22. Today, Mr. Devadas.
this has been argued. Yes, Mr. Kumar. Mr. Kumar.
Please.
Yes.
May I request the court to kindly.
You want to appear in 2347?
Yes, 2347 I appear.
All right. Give
Please.
the file.
I'm also appearing, my lord. I'm joining to a lordship, my lord. Early in the morning, I also gave your lordship trouble, but that was not a proper bench. A.M. Dar, senior advocate from Delhi, my lord. I have filed a fresh petition that is 3418. 3418. Early in the morning, I filed that petition, subject to your lordship's approval, permission, anytime, my lord. When your lordship would feel convenient, can also hear me that fresh matter, my lord. 3418.
All right.
I'm grateful. Grateful.
2347. Yes, Mr. Kumar.
Yes, may I request the court to kindly take the statement of objections filed by the state. They have filed a common.
No, I just want to point out something factually, my lord. If my lords are to see the petition which Professor Ravi Verma Kumar is now arguing, that is WP 23447 of 2022.
Yes.
The petitioner is one Srimati Resham. Kumari, it has to be.
Yes, Srimati Resham.
Now, my lord, this very petitioner had filed has filed in fact 2146 of 2022, in which Mr. Sanjay Hegde has argued.
She has filed 2 petitions.
Yes, she is one among the 5 petitioners. Petitioner number 2 in 2146 of 2022. When it shall just complete, 2146 of 2022. Petitioner number 2.
2146.
It's the same person.
Yes.
So they are the same persons, but they may have to justify, either withdraw one of the petitions. And they have been argued at length by Mr. Sanjay Hegde and so forth. Of course, if my learned friend is arguing on questions of law, I don't have any objection, but I must point out that this second petition will not be maintained.
In this petition, 2347, there are 2 petitioners. 2 petitioners. One is Srimati Resham, the other is Sri Mubarak.
No, that is not through next friend, Mubarak. She is 17 years, so therefore she is represented through Mr. Mubarak.
Resham is the petition number 2. The moment I came to know about this fact, I filed a withdrawal memo in respect of petition number 2. It's also there on the record.
Which petition?
2146.
21.
Respect of petition number 2. Already I filed a withdrawal memo on the very same day.
2146, you have moved a withdrawal.
Withdrawal in respect of petition number 2, who is the none other than the petitioner in another petition. That controversy is not required.
That has not been allowed.
We already in the record for the very first time, the learned judge has said that, honorable judge has said that it has to be close together, and we will consider it. The memo is there on the very first day in the record. Even I got in the notice of the court also, same day.
No, the point is, my lord. No, the point is this: on behalf of Resham, arguments, the questions of law and facts, arguments have been addressed. If they want to assist your lordship, this is different. But the same petitioner cannot urge the same questions of law on facts, based on same facts again and again through another counsel. That is what I want to point out. That is question of duplication of efforts and saving the precious time of the court. This is not this to the learned senior counsel who wants to address some questions.
We are argued on that day on respect of preliminary prayer. Interim prayer only is argued on that.
No, he made a statement that he wants to argue finally. Before us. We asked him whether he wants to make submission on the interim relief, or finally he said we want to argue finally.
Interim relief, he was arguing on interim relief. Several points he has not raised it. Now, and Mr. Tanvir is going to continue the argument from that. There will no duplication on the fact.
No, sorry, Mr. This way will not allow. This way we will not allow. Mr. Hegde has made his submissions. We have noted it. And he made it.
May I most respectfully, my lords, make a mention? My lords, Mr. Hegde, my lords, made his submissions at the prima facie stage in 2146. My lords.
Where are you? Yes.
Mr. Tanvi is working.
My lords, my lords, I'm from my chambers at New Delhi, my lord.
Yes.
Now, my lords, thereafter, my lords, I was, my lords, instructed.
You said you will appear in a fresh case which you have filed today. We will hear you.
That I have filed. I have filed one.
My lords, I am for the original petitioners, my lords, in the line of chronology. 2146, my lords, is the first petition.
2146.
Mr. Mir should wait. Mr. Mir should wait when the senior advocates, my lord, would address. They have the privilege, my lord, that your lordships have been permitting the seniors so that they will, my lord, put across the constitutional points. Mr. Mir should wait, my lord. He has been disturbing.
I don't think, my lords, my learned friend should, my lords,
wait.
even speak.
Please
I'm
wait.
making a submission to the honorable court. I don't know.
Yes, that's what we are saying.
Now,
I filed a fresh petition early in the morning.
On the first day, you people cannot decide as to who is to argue first.
Please, your lordship. It is only the honorable court. That's correct.
And let us one thing be very clear that we will hear only one counsel in one case.
Absolutely correct. Your lordship is right.
My lords, as far as 2146 is concerned, my lords, at this stage of final hearing, my lords, I would like to make some submissions.
Mr. Sanjay Hegde has already made his submission in 2146. Now we will not permit any other counsel to argue on that.
Okay, Mr. My lords, then allow us to, my lords, file a written submission.
Written submission he has already submitted.
My lords, that was, my lords, at this stage of preliminary. My lords, initial argument leading to an interim order. My lords, as your lordships have heard, Mr. Kamath, my lords, finally in the matters, we have also done some research which we find, my lords, will be of great importance to this honorable court.
Please don't waste time of the court. Let's say hear the other counsels. Yes, Mr. Ravi Kumar Verma. Ravi Verma Kumar.
My lords, we have submissions in addition to this, my lords. If your lordships permit,
He
we'll
has been
only get
disturbing
final
always,
written
my lord.
argument.
Is the honesty ought to disturb everything well.
May I request the court to kindly permit me to show from the statement of objections?
Yes.
What is the source of which the government has emphasized? They are very succinctly set out.
Mr. Ravi Verma Kumar, let's first understand the status of this petitioner. This petitioner has filed another writ petition in which he has filed a memo for withdrawal.
Yes, I respectfully agree that there cannot be two petitions by the same petitioner.
He is not pressing that writ petition. Now she wants this matter to be argued by you.
Yes. She wants to withdraw the other petition that was filed along with a batch of students.
All right, then in that petition we will allow the memo for withdrawal.
Yes, that may kindly be. I'm grateful.
And you argue on behalf of the petitioner in this petition.
Yes.
Yes.
May I request the court to kindly permit me to point out paragraph 12 of the statement of objections. This is the sheet anchor of the respondent's case as to why they have prevented the students from entering the school college.
This would be allowed on behalf of. This is to be allowed.
That memo is in fact listed before the court today. It is shown in the cause list.
2, 3, 4.
Shown in the cause list.
Statement of objection is filed in this matter, but petition is argued. This petition is being argued. The petition.
This statement of objection is not there.
It is not filed in that matter. It is filed in the
Mr. Ravi Verma.
Please.
Statement of objection is not there in 2347.
It is a common statement of objections filed in 2146 of 2022 connected with 2347.
Yes.
Kindly see the maybe I don't know whether they are not whether they are.
All right. Yes, a statement of objection is there in 2347.
Please, kindly come to page 15. Para 12.
Yes.
It is submitted that respondent 5 institution has followed the Karnataka Education Act 1983, the Karnataka Education Institutions Classification, Regulation and Prescription of Curricula, etc. Rules 1995, referred to above, and directed the students, kindly mark this, directed the students to follow the uniform dress code in the college campus and classrooms. The long-standing practice of this uniform system is a settled fact, accepted and admitted by the College Development Committee under the chairmanship of local MLA and other office bearers have discussed the subject on 31/1/2022. Kindly mark the date. I was prevented from entering the class or the school 3 days prior to 31st. On 28th, I was prevented from attending the classes. So they are banking upon a decision taken on 31/1 in the presence of some of the petitioners and their parents. The request of the petitioners was discussed at length. After analyzing the law, public order, and notions of secularism, kindly mark it, who are doing this? Notions of secularism, equality, and conflicting interest, it was decided that the existing uniform system shall continue. The students in petitioners cannot be allowed to wear hijab inside the premises of the institution, and if they violate the dress code and wear hijab, such act shall amount to violation of code of conduct of the institution and be considered as a subject matter of disciplinary action. Kindly mark this as a code of conduct of the institution. Kindly mark it. I'll show for a moment. There is no such code of conduct. It was made clear that strict action shall be taken against such indiscipline, and thus students were requested to follow the discipline and uniform dress code prescribed by the college. Copy of the resolution dated 25/1/2022, 31/1/2022, produced as Annexure R3 and R4 respectively. Para 13. It is submitted that the state government, in exercise of its power of superintendence and control over the institution under the Karnataka Education Act, issued directions on 25/1/2022 that the government is examining, kindly mark it, that the government is examining the larger issues of dress code and uniform system up to PU level, and there are conflicting views and interests in the subject, and in view of the sensitivity involved in the matter, a high-level committee is being formed to examine and report back with the recommendation to the government. In the meanwhile, it was also directed that respondent number 5 college shall continue with the existing uniform dress code till a comprehensive policy or decision is taken on the subject. The said direction of the government taken on 25/1/2022 and of the above proceedings of the College Development Committee on 31/1/2022 has been specifically communicated to the students through instructions dated 1/2/2022 by registered post. Copy of the directions are produced as R5 and R6. So kindly mark it. The government is yet to take a decision. It is constituting a high-level committee which is going to look into the matter, and only after that deliberation is over, then a final decision is taken. As of now, government has not prescribed any uniform. Government has not prohibited wearing the hijab. Now kindly see para 19. Para 19 at page 29.
Para 19.
Para 1919, page 29.
Yes.
It is pertinent to that the government of Karnataka exercising its power under section 7(1)(I), 7(2)(g)(v), read with section 133 of the Karnataka Education Act 1983 and Rule 11 of the Karnataka Education Institutions Classification, Regulation and Prescription of Curricula, etc. Rules 1995 has issued Government Order dated 4/2/2022 regarding uniform policy for educational institutions in the state. Kindly mark, there is no prohibition for wearing the hijab here also. The said notification has been issued having regard to the conflicting views, demands by various educational institutions and students at large. After rising up the issue involved in these petitions, the students of various institutions of state of Karnataka have started insisting of clothes to be worn to their choice. They are seeking for relaxation and exemption from following uniform dress code prescribed by various institutions governed under the Act. In order to resolve the controversy, the government thought it appropriate to prescribe uniform dress code by virtue of the order dated 4/2/2022. Copy of the order dated 4/2/2022 is Annexure R8. Let us see whether there is any prohibition for wearing hijab in Annexure R8.
Page number?
Page number 116, the Kannada version. The English translation has been handed over to the court. I do not want to go into the controversy of Suvyavaste. It is definitely Avyavaste. Kindly come to the operative portion of the order. I will not trouble the court with the preamble to the order. So certain assumptions are made, certain opinions are formed. Sir, the order starts at page 116, 116. It is in Kannada. The English version has been handed over to the court. There appears to be a typographical error in the statement of objections. The order is dated 5/2,
Not 4.
not 4.
Whether it is 4/2 or 5/2.
5/2. Order says it is 5/2.
5/2 we have got. Just
Impugned government order.
That is the
Stated as
impugned government order.
4/2, yes, impugned order. Impugned government order.
Is it 4/2 and
So
5/2?
if there is no 4/2, there's a mistake in the statement of object. It is 5/2.
Mistakes are not only in words, figures also.
Please.
Yes.
Kindly come to the operative portion of the order. Yeah. Just before that, what they have summed up may kindly be noted. As the Supreme Court and various high courts have held that restricting students from coming to school wearing headscarves or head covering is not in violation of Article 25 of the Constitution and after carefully examining the rules under the Karnataka Education Act 1983, the government issues the following order. In exercise of the powers conferred under section 133(2) of the Karnataka Education Act 1983, we direct students of all government schools to wear the uniform fixed by the state. Students of private schools may wear uniforms prescribed by the management committees of the school. Kindly pause for a minute. Government itself has said they are yet to decide on the uniform. There is no uniform prescribed by the government. They are constituting a high power committee to go into that question. That issue is yet to be decided. In the meanwhile, they say school they should wear uniform fixed by the state. So as and when it is going to be fixed, it shall be taken note of. But as of now, this order is premature because no uniform has been prescribed. The students of private schools may wear uniforms prescribed by the managing committees of the school. In colleges that fall under the Karnataka Board of Pre-University Education, dress code prescribed by the College Development Committee, kindly mark it. Dress code prescribed by the College Development Committee or the Administrative Supervisory Committee must be followed. If the administration does not fix a dress code, clothes that do not threaten equality, unity, and public order must be worn. Kindly take note of the fact there is no ban of wearing hijab by any students, much less students of religious minorities belonging to Islamic community. It says the development committee will fix it. They will prescribe the dress code. Till then, clothes that do not threaten equality, unity, or public order must be worn. We are not violating equality. We are not violating unity. We are not violating any public order. Be that as it may, there is no order against hijab. That is the sum and substance of this. Now they have provided that the College Development Committee shall prescribe the uniform. May I request the court to take the Act, Karnataka Education Act. Sir, this is a complete code in itself. Entire aspect of education to the level of PU is covered by the Act.
You want to refer section 133?
No, I point out that this College Development Council is a non-existent body under this statute. It is an extra-legal authority which is endowed with the power to prescribe the uniform, contrary to the scheme of the Act and the letter of the rules.
Yes.
May I request the court to kindly note down under section 2, the definition clause, all the authorities that are entitled to exercise power under the Act are specifically defined. Subsection 7 of section 2 may kindly be erased. Subsection 7 of section 2 competent authority. It means any person, officer, or authority authorized by the state government by notification to perform the functions and discharge the duties of the competent authority under all or any of the provisions of this Act for such area or for such purposes or for such classes of institutions as may be specified in the notification. This is a competent authority not endowed with any power to prescribe the uniform, and College Development Authority is not, Development Council is not. Then kindly come to the Managing Committee under subsection 19. Before that, Governing Council may be perused. Subsection 17. Governing Council
Yes.
Governing Council means any person or body of persons permitted or deemed to be permitted under this Act to establish or maintain a private educational institution. Kindly mark. Or a commerce institute. Or a tutorial institution. And includes the governing body by whatever name called to which the affairs of the said educational institutions are entrusted. Sir, this is not a private college. It is not a tutorial institution. It is not even a commerce institution. Commerce institution is defined under subsection 9. Kindly permit me to show. Commerce institution means any institution imparting commerce education and presenting students for examination conducted by the Karnataka Secondary Education Examination Board, that is up to SSLCA and below, like typewriting institutes. They are all called as commerce institutes. Anyway, it does not include a pre-university college. And then tutorial institute is also defined.
214, Professor.
Please.
214.
Yes, educational institution means educational institution, any institution imparting education referred to in section 3 includes a private education institution, but does not include an institution under the direct management of the university or the central government or a tutorial institution. This
All
is
right.
what
You say that the College Development Council is not defined in this definition. It is
not an authority under the provisions of the Act.
It is not a statutory body under the Act.
Not contrary.
We will continue tomorrow.
Very well.
Please, Your Lordship.
In WP number 2146, 2022, has been concluded. The arguments in writ petition 2880 of 2022 have also been made by Mr. Devdutt Kamath. He has completed his arguments. Mr. Ravi Verma Kumar, senior advocate, is arguing in writ petition number 2347 of 2022. He is continuing with his arguments. Put up tomorrow at 2:30.
My petition be also clubbed with my Lord's permission, 3418. Be clubbed.
May I make one submission? The
3418.
opening
Withdrawal in that petition.
1 second.
shall be stand allowed. And the petitioner in that writ petition shall, the petition on behalf of President shall stand dismissed as withdrawn. Yes.
The colleges are reopening tomorrow.
Yes.
I therefore fully submit that the application I had made yesterday.
That application is same defective. It does not have a verifying affidavit by the party. It is by the council, Murad, on record based on his own knowledge.
Lordship,
we can't respond. But anyway, I have my submissions to be made on that.
Lordship, may I make one submission, Lordship?
1 second.
I filed this application, senior counsel has filed application in my petition, Lordship. And I have presented a memorandum of fact. And I have stated also reason for what reason I am presenting a memorandum of fact. Because petitioners, they're in Udupi. It's very difficult for them to come all the way to Bangalore to file a...
That way it is not maintainable.
Lordship, kindly appreciate, Lordship. There is also provision if the memorandum of fact can be supported.
Because under the Karnataka civil rules of practice, if my lords are to examine rule 17, 18, no, I'm just pointing out. Memorandum of facts can be sworn in by the council only in respect of matters which are on record. And these are all not serious allegations made. So, kindly permit me to...
Lordship, there is...
Then in the High Court.
Before rising, my lord, that submission might be, my lord, 3418, maybe also collect.
It's also here. This rule we have adopted under Rule 37 of Proceeding Rule 77.
Civil rules specifically mention the situation when the council can present a memorandum of fact, Lordship. These things are there in the civil rule. Relying on the same position, I have furnished my memorandum of fact along with my application, Lordship. And I have specifically mentioned the reason for what reason they are not able to furnish affidavit. In their absence, with their consent and permission, I have presented a memorandum of fact along with the application, Lordship. So I cannot be prevented from that application, Lordship.
A bad practice. This is
Lordship, rules are there.
Practice. This is not a correct practice. Application has to be accompanied by an affidavit, which is to be sworn by the petitioner or his authorized parocar. A lawyer cannot be authorized parocar.
Lordship,
so we will not allow this bad practice to begin with. A lawyer cannot be permitted to sworn an affidavit.
May I make one submission, Lordship, in this regard, Lordship? Lordship, there is kindly peruse the civil rules, Lordship. There is only 5 occasions was provided on which affidavit is necessary.
We will reject the affidavit.
Affidavit necessary, and all other occasions, memorandum of fact also can be furnished along with the application. The parocar system is not there in the South India, Lordship.
Advocate is rejected. We'll continue tomorrow at 2:30.
May make a submission, my lords. The statement of objection filed by the state is not served to the petitioners, my lords. Kindly direct the state to further copies of the statement.
Will a copy. I don't know. Will serve.
Before rising, my lord, one submission that my petition will be also colored, my lord, 3418. I shall be grateful, my lord.
Let it come before the court.
That is before the bench secretary, my lord. It's filed today early in the morning, my lord. Fresh petition.
Come today.
Please, Lord.
It will be listed along with them.
Please, grateful.
My lords, I am Dr. Vinod Kulkarni, party in person. I may be kindly heard tomorrow, my lords, for the same petition.